How do you protect your assets when you might be getting sued or being attacked by creditors? How do you make sure that your house is protected, or the rest of your property for that matter? In this video, we're going to find out exactly how to do that. Hi, my name is Tyus and I make videos about personal freedom, escaping the rat race, living your freest life, and you can't really have a free life without some level of safety and security in place. I got the opportunity to sit down with Kurt Kaplan, who is an attorney who specializes in asset protection and estate planning. Now, if you don't have assets yet and you're working on building that estate and that net worth, then check out my other videos that I will link right up here, and those show you how to escape the rat race, how to build your net worth, how to get out of debt should you need to. Now, if you have not yet subscribed to my channel, hit the subscribe button once. If you have already subscribed, hit it twice. And if you never intend on subscribing, hit it 3 times. Now, in this video, I need to warn you that one of the primary mics I used gave out at about the 20-minute mark. Now, we still caught the audio from some backup microphones, but it's not as good as the primary mic. I want to apologize for that, but there's so much value in this that I really wanted to make sure that it's available to everybody. And so, without further ado, here's that interview with Kurt Kaplan. Okay, so I'm here with Kurt Kaplan. Thank you so much for joining me. Let's go, like, our little backstory here is that we both have some interest in magic, and
yes.
we both have backstory within that. However, I found myself at a party, and you're there, and somehow law and asset protection comes up, and you blew my mind in like a very short period of time. Just answering some simple questions, and other people had questions too, and I was like, this is amazing stuff. More people should know it, and it's what you happen to have some expertise in that area.
I do, yep, and we were at a magician's birthday party.
Yes.
Is what it was. And what's great about magicians is we don't talk about magic at our parties. We talk about other stuff, and this will happen to be one of those subjects, right?
Yeah.
So
what got you into this profession?
I guess my father was a doctor, and he was looking for some ways to protect his assets from lawsuits and litigation. And before I went to law school, I was a fiduciary accountant, which means I helped probate personal representatives, executors, trustees account for their funds that they're going to be managing for the trusts and probate estates. And what led to it is there was a lot of questions about how do we protect these matters from creditors. And then I ended up one day, I just applied to law school, and here I am.
Okay. Well, I gotta think that it's probably very nice to not have to be on the side of the law where people are fighting with each other and all of that. I mean, I guess there's probably some arguments around assets.
Right.
But I would assume that there's a lot of people that's all they're dealing with. They're dealing with personal injury, they're dealing with like literally these bickery things, and I feel like what you're covering a lot of is making sure that you're being able to protect people and helping them out to the best of your ability within like things that are very meaningful and valuable to them.
I agree. We call that friendly law, where people are really here to like, thank you very much. I want to pay you money for helping me protect my assets, helping my children protect their assets. So it is a friendly side. There is no adversarial work to that.
Yeah. So, okay, so just to dive into it, what is asset protection? How is that defined?
So asset protection really is a way to structure your estate so as you can have enjoyment of those assets while at the same time protecting them from your creditors, possibly future ex-spouses, things like that.
Okay.
Asset protection, though, let me tell you this, since asset protection is created fiction within the different state laws, the state laws also exempt that you're not asset protected against a federal government or the state government. And you know that if a government wants to do something, it just does it. So that's the only thing the assets don't protect against is some federal action or some state action.
Gotcha. So basically, even though the government might be the creditor on the other end of it, you can only do so much.
Well, there's probably some exception there that allows the government to get through to the asset.
Yeah, if they wanted to, they're going to take it.
Right.
Yes.
Right. That's why sometimes, do we want to be armed, things like that.
Yeah.
But that's a different discussion.
That's a very different discussion.
Yeah,
the libertarian in me really wants to go down that route.
Right.
But before we do, let's go into more on the asset protection stuff. What is the difference between like asset protection and estate planning?
So they can be totally separate, and they can be the same thing.
Okay, let's go for the separate part because the same will be easy.
So estate planning is essentially where you're arranging the title of your property so as to avoid probate, possibly minimize estate taxes after death, or avoid guardianship court. And what I mean by that is if you have assets funded into, say, a revocable living trust and you become incapacitated, those assets will be managed according to the terms of the trust, not according to what the guardianship court says if you become incapacitated.
So are you saying that essentially estate planning is protecting for your death, while asset protection is potentially for debtors or anything like that? Like if somebody trying to sue you or something like that would fall into asset protection, while estate planning would fall into what happens when I'm no longer here?
Okay, so let's break it down a little bit more. No, you're on track. Let's break some more here. Estate planning is more of planning for life situations in times of incapacity, and then what will happen to your assets after death.
Okay.
All right. Asset protection is a life planning aspect also, but it has a little bit of a different twist because you're trying to protect against creditors, whereas other estate planning, you're just trying to avoid probate, you're trying to pay taxes and etc. Asset protection is also a life planning technique, but also after you die, we'll dispose of your property some other way.
So does estate planning fall under asset protection, or does asset protection fall under estate planning?
They're kind of intermixed. They're kind of like two nuclear stars kind of right next to each other, and they mix sometimes and other times they don't.
It's a Venn diagram.
Right. There's something, exactly. That's exactly right, a Venn diagram.
Okay. So what assets could you protect, should you protect, can you protect, that most people are interested in? I'm assuming property is going to be a big one on that list, but I'm sure there's other things.
Okay, so we're talking the asset protection.
Yeah, we're talking about...
Are we talking Nevada?
I'm talking in the Venn diagram of asset protection or estate planning. What do people protect intentionally? I'm going to guess from the broad strokes of it, they're going to protect their personal property, literally their house.
They will protect their house. That's the first thing they protect.
Yeah, and then maybe the bank account might be second or something, or retirement account.
Usually an investment account is protected second because it's the easiest thing to work with. Retirement accounts can be protected, but there's a lot more work involved.
Okay.
And we can talk about that later if you want. Otherwise, we can do it on a different day. But it's mostly the house first is protected, then investment accounts. Then if they have land located within Nevada or something, they will, or maybe a business, they will transfer it to an asset protection trust in Nevada.
Now, speaking of Nevada, so we're in Nevada, we're in Vegas.
Yes.
But a lot of people that view this are, well, actually we have international audience members. So how does this work law to law, state to state, country to country? Is it so specific that you have to set it up within your hometown and figure out the laws of that county, or do you just need to understand the federal level of it, or how does that break down when you're hiring somebody or doing it yourself? How specific do you have to get within geography to make sure you're doing this right? All
right, so for every state out there, there's a different way of reaction. From some states just abhor public policy-wise is no asset protection.
Wow.
To where you go into other states such as South Dakota, Nevada, and Delaware, and Alaska, where there are strong asset protection trust language that exists. So a lot of times,
we're one of the better places.
We're one of the better places.
Okay.
And I mostly spend like 99% of my time inside of Nevada law because I just understand it. I live here. I live and breathe the statute. We do some work out of Alaska, but I always bring in counsel up there.
Is Alaska a good one too?
Alaska is also good. It's got some things that are a little bit different than Nevada law, and they're kind of quirky. And I'm gonna get into the weeds, and I don't want to hurt people in that. But Alaska is also another great asset protection state.
Is it similar to how you can set up a company where like a lot of people will set up a business in Delaware because I don't know, it seems to have good
well, laws. They have phantom, yeah. In Delaware, you have, my understanding is you have phantom officers, where you can set somebody up as an officer and director, and you can hide the true owner of the business. Nevada used to be that way, and is still in a way that way, but what's going on in registered agents now must know who the owners are, so if someone comes knocking, that they can find the owners.
What I mean is, let's say I own property in a state that is not really good on asset protection. Let's say, I'm going to guess California.
Right, that's a good one.
I'm just going to throw that one out there. And
that's a good one.
If I'm throwing a dart against the wall, it seems likely.
That's the hardest state to work with.
Yeah, so let's say I live in California and I've got property there, and I want to protect that property. Could I set up a trust in Nevada and put the property under ownership of that trust in Nevada, or does it have to be? Do I have to work with where I live?
All right, so what I always think about is when I talk to people is when you're extending your asset base or where your assets are located into different states, you just have to know that you're subject to those state laws, because the state could actually just ignore the way the title is held and just say, hey, you're voiding public policy, we can just take that property. Okay.
Oh, this is terrifying.
So what I'm saying is this, is that yes, we do work where we'll set up an LLC. That LLC will then own, a Nevada LLC will then own an asset, say in another state, Colorado, where I'm also licensed, Colorado, and then we'll have that asset owned by that LLC here in Nevada. I just let people know that we need to make sure that that asset, you stay hidden from that LLC so that they don't find that on the radar.
Wow, okay. So the answer is yes, you can do it that way.
You just have to be a lot of work and careful.
Got to know what you're doing. Got to be cautious.
And if they find out, and if there's ambitious attorneys out there, they're going to go at it.
Gotcha. So before we get into what attorneys can help us with and what people like you can help us with, and you specifically, let's go into what people can do for themselves and like the low-hanging fruit that I think a lot of people might be missing that they probably shouldn't be missing. So, like for example, I guess we could start at the most basic of it, which would be like insurance. Is there particular kinds of insurance that people should be getting, or is this an absolute waste of time when it comes to asset protection?
No, that is actually one of the first levels of asset protection. When someone walks into my office, the first thing that I want to know is asset protection appropriate for them, and if it is, at what levels that is. So sometimes just buying an insurance policy that costs you an extra $500 a year, to have an umbrella policy for $1 million on your house. So if somebody falls down in your house, they're not taking it from you, they go after the insurance policy. So that is always a basic asset protection for anybody. The downside is you're paying the premium every year for that asset protection. The next level, which is actually super easy, people can do it, they can download a form, is declare a homestead on your house.
What is a homestead? Because people toss it around when you buy a house, they send you something in the mail.
Right, and you
but then
send them $35. Like,
I don't know what this is, whatever.
Right.
So what does it really mean? What does it do?
So homestead, Nevada public policy is that they want to make sure that if somebody makes a mistake, that they don't become homeless, that a creditor, a judgment creditor, meaning someone who won a lawsuit, can come and take your house from you and make you homeless. There's that policy. We don't want people homeless. So Nevada allows people to declare a homestead, where you actually have to record something in the county recorder's office in which the property is located, that you are declaring that piece of property as your residence, or I call it abode, which means that's a place that you return regularly for shelter, to get away from, and for privacy, etc. You cannot have more than one abode in any one location. So you can't have a house here and then a house in California. And if you live really in California, you can't declare the Nevada house in your abode. You have to return to it regularly. So you have one homestead at all.
That's it. So
that's it.
Pick one, that's what you get.
Pick one and that's it.
And this is going to protect you from
creditors
being able to take the house, but they can still like put a lien on it or something.
They sure can take a lien on it, but the one thing is you're protected up to $550,000 in equity.
Wow. For $35.
For $35, you protected in equity, and there's some other advantages for having a homestead. You know, like I think I told you at the party that there was one time I had a child living with an heir, and there was a casino that had a lien on the house because the deceased had a marker with a house. I pretty much extinguished the whole marker because the value that we protected up to $550,000 was conveyed free of the marker's lien on the property. So how it works is, let's say you have $100,000 you owe on a house. Your house is worth $600,000. if you subtract the mortgage from the value of the house, you have $500,000 in value. You apply the homestead, you are completely protected from any liens. From people foreclosing on your home.
Wow. Okay.
So let me give you one more example. A homestead would say your home is worth $700,000 and you have zero mortgage on it. That means you have full exposure to some type of claim from a creditor. You apply a homestead, you have $550,000 protected, but 150 of the 700,000 is subject to liens and foreclosure.
Okay.
So that's how that works. The 550 exemption.
But price for protection.
$35.
Hard to beat.
Yeah, and when somebody does estate planning with me, when I'm doing a trust planning for them, I just by gift give them the homestead because it would just be stupid not to do that for them.
Yeah, that's awesome. So getting slightly more advanced, I guess before we get into LLCs, because I'm very curious about LLCs.
Sure.
Let's talk about wills, because I think a lot of people, when they're thinking about estate planning and things of that nature, they're thinking about like, okay, I've got to write out a will to make sure my next of kin are protected to get all this stuff that I want them to get. Are there any best practices or anything around that? Or anything around that?
Well, let me see if we can go back and let's place the will into the proper place in estate planning.
Okay.
So I'll first tell you that a will is simply a letter written to the court telling the court what you want done with probate property. Now that's a really action-packed, really boiled down definition.
Yeah, there's a lot of keywords in that.
If you'll notice, I said letter to the court telling the court what you want done with your probate property after you die. All right? That says that a will only kicks in after your death. So it doesn't avoid any type of probate. Because remember, when you write a letter to the court, when you write a letter to somebody, you want them to read it. So if you have probate property, then the court will read the letter and say, after probate, this is what I want, this is where the property is to go to child A, child B, etc., to a charity, wherever. So a will does not avoid probate. It only directs through the probate process where your property is to go after probate is complete.
Okay, so explain probate, because it's one of those weird legal words that people hear and they might, when I read a book and there's a word I don't understand, I then will read like 5 chapters ahead and realize I have no idea what I just read because my brain got caught on probate, right?
That my brain does the same thing.
Yeah.
I will spin on something like that until I figure it out, right? And someone will come and just clarify, it's like, oh, that's what that means.
Yeah.
Okay. So to help you out what probate is, I need to kind of go through the 3 ways you convey property at death.
Okay.
All right. The first way that you convey property at death is by operation of law. And everybody, like married couples, will hold property as husband and wife joint tenancy with rights of survivorship. That essentially means by operation of law, upon the death of the first spouse, the surviving spouse, by operation of law, receives that property. No probate.
Okay.
All right. The second way that you convey property at death is by contract.
Okay.
And a good example of that is life insurance. Upon my death, pay this person.
Okay.
Right? And oh, by the way, a trust is a revocable living trust that says convey my property at death is also a contract. It's the same thing as a life insurance policy. Upon my death, pay this person.
But a will is not a contract.
No. So the third way you convey, so we don't convey by operational law, nor do we kind of convey by contract, which is life insurance or a trust or whatever. The third way is the default way, and that is probate. And probate is the process that must be followed through the court system to clear title from the name of the deceased individual to whomever is to receive according to the will, or if someone dies without a will, according to Nevada statutes, they're called intestacy statutes.
So basically, probate is a court of law in the same way that like small claims is a court of law. And
Yes.
all they do is they go, hey, this person died, where should their stuff go? And if you wrote a will, you essentially sent them a letter saying, hey, just so you know, this is where I want my stuff to go.
My probate assets.
Yeah.
Right.
But the problem with this is that there's a cost associated to this, right?
And yes, cost in time and money.
Yeah. So what are we looking at if all we did was set up a will, and let's say for round numbers I had $1 million in assets and stuff that the probate court is trying to decide what to do with, how much am I losing to the court?
Well, it's not that you're losing money to the court. I just tell people that you're going to have about $1,000 in court fees, publication costs, copies,
Just stuff.
postage and stuff like that. I just tell people, just know at $1 million estate, and I'm assuming $1 million estate is a house, a car, a bank account, and maybe an investment account. If you have something that's like a business or something, that's more work, so that has a different issue. But just assume that you have a basic, average American car, house, savings account, and maybe an investment account.
Gotcha. Okay.
So you've got costs of $1 million. Now in Nevada, you can take percentages of the estate, and I don't have off the top of my head what that would be, but I'm going to guess, if you took a percentage of the estate, that I'm going to guess $15,000.
Okay.
In legal fees.
Yeah.
And the costs, everybody thinks that there's court costs. It's about $1,000 in costs. Mostly it goes to legal fees.
Gotcha. But those legal fees could add up, because let's say that very little of that is in cash or something that.
But if it's in a business.
Yeah.
Let's say it's in a business, then you've got to petition the court to get certain permissions to run the business until you can either shut it down, cash it out, or sell it. And then that whole process of selling could cost other legal fees.
Yeah, but let's say my father died and all he left me was a house, right? But I've now got to pay all these fees in probate and all this other stuff. And if I don't have the cash on hand, I might have to sell the house that I wanted to keep just to pay for all the fees.
Or mortgage it. Yeah, I've helped heirs when we know, what I've done is I've helped heirs coordinate so that when they receive the house, that they're going to be able to start cashing it out pretty quickly after receipt of it. So I worked with mortgage companies in that regard.
Yeah.
Because I've had heirs in that exact issue.
Yeah.
And if they just only been living with a parent when they died, they'd receive it pretty quickly without, all that issue.
Gotcha. So a will basically is a letter. It's not doing a whole lot.
It's just a letter to the court telling the court what you want done with your probate property.
Gotcha.
So remember, if you don't convey it by operational law, nor by contract, you have to go through probate.
Mm-hmm.
There's no other way to convey property. I don't care how you've heard about it on a podcast, read it in a newspaper, magazine, heard about it at a party. There's 3 ways they always go down.
So the contract one is the best to do.
That's correct.
But it takes a little bit of foresight.
Yeah, and you got front-end work costs also. So you've got front-end work, meaning you're going to pay some costs, and then also you've got the work of actually transferring the assets to title those assets into the trust.
But is that going to be significantly less than?
Significantly less.
Yeah.
So $1 million, let me just tell you, $1 million estate, which is say I said 15,000, I could be wrong what that number is.
That's fine.
Ballparking it. So just think 15,000. If you did it by trust administration, let's say you did all the work and all that, probably the cost for $1 million trust administration would be, instead of 15,000, would say would probably be around $6,000.
Okay. Yeah.
So you save
That's significant.
$7,000 or $8,000.
Yeah, that's significant.
Yeah. And you keep your privacy. You don't have all the stuff published in the public record. Because remember, probate is a public process. So you have to publish notice to creditors, and all that stuff. You have to publish the assets, unless everybody waives it, which is a different issue. So you've got a lot of public stuff in a probate, where the trust, we can keep things private.
Gotcha. Which is probably great for your heirs if they're dealing with that.
Yes, and people do not need to know how much other people are inheriting. We're in the public process, you will know that.
Yeah. So we touched upon LLCs briefly. Mm-hmm. I'm fascinated by this because in many ways people are like, oh, it's a great way to protect your assets, and then I kind of dive in and I'm like, I don't understand exactly how this is a great way of protecting your assets. So can you explain how people use LLCs, which is a limited liability company, essentially an entity like a corporation, to protect their personal assets?
Well, the one thing is that Nevada law just says that you can create an LLC for any purpose, which what they've done is they've removed the business requirement purpose in Nevada, which that was a way that the creditors would get to it, that, hey, somebody went and put their bank account into it, and then it's not being used for a business purpose, so they'd say, hey, that's really just a sham, and they got into the LLC that way. So the Nevada law has been modified that you can just establish an LLC for any purpose,
okay.
Lawful purpose, I should say. Some things are restricted, like I don't think banks can be or something like that, but for the most part, any average person can go and establish an LLC.
You can do it online.
Do it online.
It's like $450 and
right.
You're done.
You're paying all fees to the Secretary of State, and then you pay your renewals of like $350 a year for your members list and your renewal and all that stuff.
And how does it protect your assets?
So what it does is that you can set up an LLC, and then you place like an investment account in there. And what you do is there's Nevada lien laws that says that if a creditor is going to collect against you, they can come and lien the interest in the LLC. They can't actually get to the asset inside the LLC.
So the interest, so they can only lien the
The
interest.
member interest.
Oh, interesting.
So you have, the LLC is owned, it's like IBM, it issues a membership interest, somebody has to own it.
Okay.
And so when a creditor comes looking and they're gonna lien, they can't actually go in and get the asset, they can only lien the member interest in the LLC. So that prevents them from getting to it. It impairs the member also because, maybe they may not be able to get distributions, because any distribution that comes out on a lien would probably have to go to the creditor.
But if it's a single member LLC, if only one person owns the LLC, by putting a lien on that member,
They pretty much vapor lock their access to it.
yeah, you pretty much locked it up. But they still can't get at it. But it's locked
Nobody
up.
can get to it.
Yeah, so
Right.
now you've just got this thing sitting there.
Right.
Okay.
And then, there's this argument that there's federal law, who pays the taxes on the dividends and all that stuff. That's a little bit beyond what we're going to talk about. I mean, it depends upon the lien and all that stuff, but that's another issue. But what I usually tell people, this is the most boneheaded thing I've ever seen somebody do. When they come into my office and
You haven't watched my show.
I just
I got all kinds of boneheaded things I do.
is what people will do is, hey, I want to protect my house from creditors, right?
Sure.
Let's go ahead and convey the title to my house. The title to my house to the LLC.
Sure.
Well, let's talk about what they just did there. They just lost the ability to get their homestead exemption of $550,000 because it's no longer considered private property, your personal property, because it's owned by an LLC. Number two, you probably just voided your title insurance, which is not a big deal. You can probably get a rider for it, but most people don't know they voided it.
When you say title insurance, I don't know what that means.
Title insurance is when you buy a house, there's a title company that will come and say, hey, if there's some type of defect in the future that you bought from this buyer, we're ensuring that you're going to have quiet enjoyment of that title. And if we find that there's something wrong, like there's maybe an easement that goes to the property that wasn't otherwise detected by us, we will pay for the value of your home in case you lose it for something.
Huh.
Okay.
So when I have a mortgage on my personal home,
And you probably got title insurance when you bought the house.
probably do.
Willing to bet you did.
But it also said something that I remember specifically where it was, if I were to transfer this into somebody else's name, they could call the note due in full at the time.
Yes, due on transfer clause.
Would that apply if I tried to transfer it into an LLC?
The answer is yes, but I say this now with really hesitancy to say most mortgage companies do not come looking and say, oh, you transferred your LLC or your title to your LLC. All they're looking for is they don't want to be a landholder, they just want to receive the annuity payment every month. So you are risking it by having the transfer on.
So it opens you up to the possibility, but ultimately they'd know that if they hit you with it, you might not be able to pay everything, and that creates all kinds of other problems.
Right. They would rather just have that money coming, okay? And they don't want to have that. And the final thing that I want to talk about is that if you transfer your residence to an LLC for asset protection, you lose what is called the section IRC, Internal Revenue Code section 121 exemption of $250,000 exemption from capital gains on the sale of a house for a single person and $500,000 for married couple.
Gotcha.
So you transfer it to the LLC, sell it 2 years later, you don't get to claim your 121 exemption.
So the stuff to put into an LLC, it sounds like property is not the thing to move there.
Your residence.
Your residence stuff.
Your personal residence.
But so if you had investment property,
yes,
go for it. If you have maybe assets like business, like cars and stuff like that, or way too much camera equipment.
You could pretty much. People can put pretty much anything they want into their LLC, with a few exceptions. Your residence, your automobiles, things like that.
Gotcha.
Not your residence, but investment property, automobiles. Put an investment account in there.
Got it. But let's transition into the more advanced stuff, which we've talked about.
Sure.
We mentioned trusts repeatedly, and when people talk about asset protection, they're always talking about trusts because I think it covers a lot of things that people are concerned about. But first off, what's a trust? Because it gets really confusing. An LLC is an entity, right? A trust. You mentioned earlier that it's a contract. But it seems a little outside of a contract. It seems like a contract that can hold on to stuff. So what exactly is a trust?
Well, a trust is actually a legal entity that can hold property, sue, and be sued. But it doesn't have a corporate form to it. So people it kind of exists out there in the ether that has no really corporate form, so they can't understand it. But essentially a trust, the types of trusts. There's an irrevocable and revocable trusts. Trusts have three parties to them. Those that create the trust, those are the ones who fund the trust, are called grantors. Those people that manage the trust are called trustees. And those who receive benefit from it are called beneficiaries. Okay. So a trust is a contract, has legal form though, that can sue and be sued and hold property.
Okay. So
and it's going to take liability on it too, hold a mortgage.
So none of those people are considered like members of the trust. They just have different roles within it.
Right. One creates it and creates the document that says these are the rules I want people to live by, and here's the money to live by it. The trustee then enforces the rules on the beneficiaries on how they're going to live on it.
And can one person play multiple roles?
Sure can. In a revocable living trust, typically the grantor is also the trustee, is also the beneficiaries. It's usually a married couple or a single individual. They create the trust. They agree to manage it for themselves as trustee because they trust themselves the most for their benefit. Where's your house, their bank accounts, etc.
Now, you said there's a revocable and irrevocable.
Correct.
So what does that mean? What's the difference?
Essentially, the difference is a revocable trust is something that can be amended, or the rules inside the trust can be changed, who gets what when, who are the trustees, or it can be revoked, saying, hey, I no longer want this, let's just take all the assets back out and go as though we never had the trust. That's a revocable living trust.
So you're saying a irrevocable living trust, or
isn't that easy?
You put your stuff in there and it's like, sorry, you can't touch it.
Exactly. What I always tell people is think about something is that you're building a ship. And as soon as that ship is built and you send it to sea, there's no changing it. It just goes on its life in sea, however you told it to navigate the oceans.
Why would anybody want a situation where they couldn't fix the mistake they might have made?
Well,
why would they want an irrevocable trust?
There is, in most recent changes to tax code here in Nevada and throughout the nation, there's a couple things that can be like do-overs. We can do it's called decanting. Everybody's heard about decanting. That's a whole different subject for a different day's discussion, but we call that a do-over. So if you really, really made a mistake, you can transform it from one type of trust into another type of trust. There's limitations on how you do it, but that's one way. Another way you can do it is you can actually create with another person that's involved with the trust called a trust protector. A trust protector is somebody independent from the trustee, independent from the beneficiaries, that can say, you know what, this is messed up, that there's been change in the tax law, or there's been another change in the law that causes this trust to be quirky or not work well. They can actually change the rules inside the trust without really saying that it's no longer effective.
So there's ways of modifying it, but is there an advantage on having an irrevocable trust? Like, does it provide greater asset protection, or what's the reason for creating an irrevocable trust when you could create a revocable one?
So, good question. So there are a plethora of types of trusts out there, and each trust does a specific thing, such as I always make the analogy to a Porsche Carrera. They're made to be fast on straight and around curves, right? Where a Ford F-150 4x4 is made to go over terrain, but is not made to go quickly like a Porsche does. So each trust is different in purposes. So the reason why you'd want to have an irrevocable trust is that those are the advantages where you can begin invoking your asset protection for your benefit. So that's a major advantage.
Irrevocable one can't do that?
Irrevocable trust is, you can hold it for your benefit. You can be your benefit from an irrevocable trust.
I see. Okay.
So like I said, you can create the trust, you can be what's called the management trustee, and you can be what's called a discretionary beneficiary for your asset protection trust.
Yeah. So like there's a guy that named Derek Sivers. He created a company called CD Baby. Mm-hmm. And when
I've heard of that.
Yeah. Really cool guy.
Mm-hmm.
Great author too.
Mm-hmm.
And when he got out of CD Baby, very publicly, he ended up with a massive amount of money, which he put into a trust and set, so he gets paid a little bit of money like every month out of this trust. And he doesn't have any of the money. Like all this, like whatever it is, like $1 billion, which it's not, but a lot of money.
Yeah, there's a few $100 million there.
Yeah, so he doesn't have access to it. He can't touch it. People can't hit him up for money. He's like, you can see exactly how much money I made because that was very public what I chose to do with the money.
Right.
Like that could be a situation where you can set up a trust.
Sure.
Or something that it's kind of a weird, creepy, strange way of going about it, but.
Well, there's weird, creepy ways that the reason why people walk in my office to do trust asset protection.
Gotcha.
Some things I want to throw them out because they're just way too risky, and other things are completely legitimate.
Okay. So like I've heard a lot about land trusts and asset protection trusts and living revocable trusts. And are there like the standard ones that people, being that there's tons of different variety that do different things, are there ones that people should study up on and learn a little bit about and go like, these are reasonable for people to know, while there's tons of other ones, don't waste your time learning everything about things that don't necessarily matter as much?
Yeah, that's a good question, and I always tell people that the entrance to estate planning is think about getting a revocable living trust, because you can avoid guardianship and probate matters. It's not really an asset protection trust. If you layer your homestead over the top of it while it's titled in there, it's good. So look up a revocable living trust and study it.
Okay.
That's a good entry point for probably 85 to 90% of Americans. If you own real property, probably a trust is going to be doing you a fine job.
Gotcha. Can a trust own a trust? Do they nest?
Now, I don't say that they own a trust. A trust can be a beneficiary of a trust.
Okay. All right.
Right.
Okay.
Right. They don't own trusts. Don't own trusts. They're beneficiaries of each other.
Okay. So
and I have layers of trust. I've done trust layering.
yeah. So you can create a flow chart where this goes down to this and so forth.
Right. Right.
Gotcha.
But there's no ownership there.
But this is stuff that gets advanced enough where you definitely want to bring in legal help, right? This isn't something that you'd say the average person should just go home and be like, oh, I pulled up a form and tried to make it work. Like, this is outside of that realm.
Yeah, the one thing is that trust planning with revocable trusts has now become pretty much a commodity. That most if you go do an investment company or something like that, hey, I'll do a trust for you if you bring all your assets over. So everybody's like competing on, hey, how much can I get it for $1,000 or whatever the number is. If you're really concerned and you want to do some protection for your children, or if you have issues in your family, more than just a canned that applies to everybody won't necessarily apply to you. You may want to spend a little bit of money to have it done properly.
Do trusts cost money on like a yearly basis in the same way that an LLC, you've got to register your officers every year?
No.
No.
It's a one-time.
You set it up, you're good to go.
Yeah, you're good to go unless things change. So maybe you lose a child and you want to amend what that child was supposed to receive 40% of a business. Maybe you amend your trust to say, now I want it to go so-and-so.
Or maybe you bought a bunch more property, you need to put that in the trust or something like that.
Good point. Putting property into a trust and taking it back out, which means placing title to the trust on that property, is not an amendment. So an amendment is changing the rules, like who's going to be trustee when, who gets property when. That's an amendment. But putting property in and taking property out, think of a trust as kind of like a funnel where it's holding all the property, and at the bottom, let's say, is death. And when that bottom opens up, that's when all the property comes out. But until then, the property can be taken out, put in, taken out, put in.
So they don't need to bring in like legal help if it's set up right. It could be pretty easy.
You can do it yourself.
Just boom, boom, boom.
Yeah, let's say you buy a house, right? You buy another house other than your residence. You can tell the title company, hey, just title it into my trust. Give them your certificate of trust, and they'll title it into your trust.
And unlike an LLC, a trust is a great place to put your personal residence.
Exactly.
Gotcha. Great. So cool. Let's. What about? So I've got some weird ones here that we'll probably just breeze over quickly. But I've heard about people doing crazy weird stuff with offshore accounts, offshore trusts. Sometimes it sounds legal, sometimes it sounds super sketchy. How is this something that you've ever played with, and is this something you'd ever recommend for anybody?
Well, in my experience, I've pretty much stopped playing with the evolution of Nevada law and how strong the asset protections are in the United States. 99% of my clients work with Nevada Spendthrift Trust or the Nevada Asset Protection Trust because it does the job for them. Going offshore, it's pretty much a toy for the very wealthy. I'm guessing 50 million and above, and you're talking tens of thousands of dollars every year just to maintain it. And if you're worth 20 or 30 million, a Nevada-based or a southern, South Dakota, Alaska, or whatever, those based trust, depending upon your preferences, will do the job for you.
Gotcha. So it's it's probably super worth it if you're crazy rich.
Crazy rich.
Yes, but for most people, not really reasonable.
Right. It's just because you got introduction fees to, like, everybody hears about the Cayman Islands. Well, you got introductory fees, you got trustee fees, you have legal fees to domesticate the trust and all that stuff. And then the problem is that if somebody really gets after you, we have a case from the federal court here in Nevada called Anderson, where they actually put somebody that had an asset protection trust offshore. They actually put them in the pokey for a while, and they had them in the pokey. Eventually, they didn't get the assets from the trust, but the people that were the beneficiaries of that trust sat in the pokey for a few months.
Wow, that's very uncomfortable.
So, I mean, that's an old case. It's probably 15 years old, but, messing offshore is a lot of technical work. You're going to be dealing with a lot of attorneys. And the question I always get down with my clients too is, how much administrative time do you want to spend in your life thinking about that plan?
Or hiring somebody that has to think about it all the time, right? Like that's a lot of resources that you're pumping out just to protect your resources. You have to have a lot to justify.
Right.
Yeah. I used to work for the largest fruit company in the world that happened to make this computer and other things, my phone, Apple,
Mm-hmm.
and a lot of people used to get mad at them because they didn't pay very much in taxes. And if you looked at what they did, everything was legal, but they had enough money to justify some crazy moves that could be done that nobody else would reasonably do. Like, no one's going to start companies in Ireland and all this other crap.
Right. No American citizen is going to think about doing that.
Yeah,
I mean, they
too
can know
much.
about it, but they just don't.
Now, can you use debts or liens as a way of asset protection?
Yeah. This is a really controversial thing in my mind. Yeah, you're talking about like friendly liens, where somebody and I'm just going to give an example. You have a family member that has a completely different name than yours, and you're willing to put a lien on your house with that family member owing a promissory note to that family member, or a business that they own, and etc. And I generally tell people that that's kind of a risky thing to do because it might be considered a fraudulent conveyance, depending upon your circumstances. Okay. And so you got to really, really watch out when you do that.
Well, that's why I put it in the advanced categories, because I think it does sound a little scary. Like on the flip side, if I have a house that I purchased and I've got a mortgage on that house, the bank that holds that mortgage basically has the lien there. So like I'm only really on the hook for the equity I have in that house.
Right. And
so
you
in
just
a
put a
sense,
homestead on it.
yeah, in a sense, that lien is reducing my liability, because the bank essentially has the liability on the rest of it.
Exactly.
Yeah.
Yeah, exactly.
So what are the costs of setting some of these things up, and what's worth it, what's outside of people's range, what's stuff that they need help with, what's stuff they can do themselves?
All right, so, we've gone back to the homestead. When you buy a house here, you're going to get a thing in the mail. Hey, send us $35, sign this piece of paper, and we'll get it recorded and you're off and running. Okay, $35. My office, I charge more just because it takes more money to do it. But just say $35. If you want to do an LLC, asset protection setup, go to the Secretary of State. You'll pay almost $500 is it to do that?
Mm-hmm.
I think their cost. This legislature are going to probably change the user fees again, so that'll change. Maybe it'll be $600 this next year or whatever.
Sure.
And then to do an asset protection trust in Nevada, like a spendthrift self-settled trust, I've seen people try to be competitive at $4,500. My trust will bounce $6,000 to $8,000, depending on how fancy you want to get.
But unlike a lot of the stuff you can do yourself, these
These
trusts
are-
can be
these
set
are-
it and forget it type of situations.
They're not. They're not a set it and forget it. An asset protection trust is you have to pay attention to it.
Okay.
And you need to structure it appropriately so that you don't get yourself bound up. Who's the proper independent person to be your distribution trustee, etc.
Gotcha. If somebody wanted to employ your services, how can they reach out? How can they find you? Where do you exist on the interwebs?
Well, you can find my website. It's called crestkey.com, like toothpaste, CRESTKEY.com. So you can navigate there. You'll see a picture of me on the website. You can reach out to me. My email is kirk@crestkey.com. And, I have some videos on my website and my YouTube channel, Crest Key, YouTube channel, and I do talk about asset protection, probate, estate planning, etc.
Well, thank you so much for doing this.
You're welcome. Thank you.
Now, there's so much value that Kirk provided in this interview, and I just want to say how grateful I am that he spent that time and gave all that value to us in having that discussion. Now, here's 3 primary takeaways that I thought were really valuable. One is that there's no reason not to homestead your house. If you own your own home or have a home that is mortgaged, homestead it immediately if you get the opportunity to. The second one that I thought was a big takeaway is that a will is really not that useful to have. In fact, it seems kind of pointless, especially if you go with the third option, which is that trust that seems to be so valuable, so great for protecting your estate. Now, if you don't have an estate yet and you're working on building your assets, again, here's that link to how to get out of debt, grow your assets, escape the rat race, all of that good stuff, all the financial videos that I've put out, those are all linked right there. Watch those other videos. If you haven't subscribed yet, please do so. Share this content with other people, and I hope to see you on the next video.